Hey everybody, Paul Rabalais here, another YouTube live stream. What we're going to talk about today is the topic of what is probate. A lot of talk out there about avoiding probate, how difficult probate is. Sometimes it's hard, sometimes it's easy. What's this all about? So I'm going to lay it all out for you today, and I want to really try to be efficient in our YouTube live when I talk about what is probate. The main reason I want to be short, to the point, and efficient is my wife just told me we're supposed to, when I finish, go eat Mexican food with two of our sons and our daughter-in-law. So that's going to motivate me to keep it to the point. Nonetheless, greetings from Bakersfield, California, LD. Great. Good to see you there. Love to see the chat. Love to see the positive discussion. Love to see the questions. So let's jump right in. I'll bounce around between presenting some information, going to the chat, and so we'll have some fun with it today. So feel free to put your positive stuff, your questions in the comments. Thanks, Johnny, for the thumbs up. All right. In fact, my wife and I have a community property regular vote. We have will with use of right for each. When one passes, will the other get 100%? Okay. So let me just hit that question real quick. Yeah. In a community property state like Louisiana, Texas, and all those states that fall, up the West Coast, when one spouse dies, regardless of how the deceased spouse's one half of the community property is left, all of the community property gets a step up in basis. Some people find that a little hard to believe, but nonetheless, it's somewhat of an advantage that people who live in community property states have. When the first spouse dies, not just the deceased spouse's half of the community gets a step up in basis, but all of the community property gets a step up in basis. And then when the surviving spouse dies, any assets they own get another step up in basis. So hope that helps, Henry. Keep going. Hello, Auntie. Yeah, good to see you again. I remember Auntie from yesterday. And good to see people from Chicago, from Kentucky. Fantastic. Lynette, hello to you. All right. So we're going to jump in from the basic to the specifics. And I realize every state has some different rules, but what is probate? If I had to give a one sentence definition of what a probate is, it's that process of when someone dies with assets in their name, like a house or real estate or a business or stock or a bank account. When someone dies with assets in their name, now this is not the rule every time, the frozen rule, and there's exceptions that I'll talk about in a second. But generally speaking, when someone dies with an asset in their name, that asset becomes frozen. And so the kind of antiquated process for getting those assets to the heirs involves the survivors going through a court and attorney involved process. Judges get involved. Judges must sign court orders after reviewing the will and verifying that the will is valid, if there is a will. And then judges sign court orders ordering that banks and brokerage firms and other third parties release or transfer assets that were in the name of the person who died to the appropriate heirs. I'm going to get a lot more specific to that with that in a minute. Now, let me just touch on the probate process if the deceased had a will versus if they didn't have a will. So if someone dies with a will and they have assets that are in their name that are frozen, then the will is going to name, and I'll call it executor. And here in the law, we have different terms, and sometimes things are called two or three different things. I'll say executor. I could also say personal representative, but the will names the person who's in charge of overseeing the court process of getting everything settled. And the will also states who the heirs are. I leave everything to my three children equally. I leave my house to my nephew, Ben, and I leave the rest of my estate to my niece, Sally. I leave $10,000 to each of my grandchildren, and I leave the rest of my estate to my children equally. So the will covers that. Now, if someone dies without a will and they have assets in their name, then there's not going to be an executor, because an executor only exists when someone left a will and named an executor in the will. So when someone dies without a will, a judge, or as we say, the court, will appoint an administrator. So likely some family member or some survivor will file the official court pleadings and say, my father, my aunt, my uncle, my husband, my wife didn't have a will. And so I'd like, Judge, for you to appoint me as the administrator because I'm the one best suited to settle this person's estate. And so a judge appoints someone, and as far as who the heirs are, well, if a person died without a will, then their state where they lived when they died, where they were domiciled, that state law will determine who inherits from the person who died without a will. And it's usually the closest relatives in some form, but each state can be a little bit different. Okay. So Carol, great, widow, create a living trust. We'll get to that in a second. Now, I will say that probate is not required every time someone dies, or even if a probate is required, certain assets that the person owned are not required to be part of the probate, court proceeding. Let me give you some examples. I'd say the most common example is from someone who has an IRA when they died, individual retirement account. It could be a traditional IRA or it could be a Roth IRA. And it's very, very likely that when they set up their IRA account, they named designated beneficiaries. If a husband set up an IRA, he likely named his wife as the primary beneficiary, may have named his kids as the secondary or contingent beneficiaries. And so an IRA is typically referred to as a non-probate asset because it has designated beneficiaries. Now, if there were no designated beneficiaries and the rules of the financial institution where the IRA is held require that the IRA be payable to the estate of the IRA owner, well, now that has to run through probate, but that doesn't happen very much. That happens occasionally. So because sometimes a husband will name his wife as the primary beneficiary, he won't name contingent beneficiaries. The wife died before the husband. Now the husband dies and there's no beneficiary name. So sometimes it's payable to the estate, and that causes all kinds of tax consequences, but that's beside the point. IRAs are typically a non-probate asset. Other non-probate assets, a similar one is life insurance. Life insurance is payable to the designated beneficiaries. If a husband dies and he names his wife as the beneficiary of his life insurance, the wife's going to get a death certificate of the husband, going to fill out some paperwork through the life insurance company, and the life insurance company is going to write a check to that surviving wife. No lawyers and no courts are needed because life insurance is also a non-probate asset. I will tell you now, states around the country are pretty quick now to change their rules to allow that more types of assets can pass outside of probate instead of having to go through the kind of old, burdensome, antiquated court proceedings. So lots of states have enacted TOD, transfer on death registration. So someone has perhaps a brokerage account at a Schwab, a Fidelity, a Vanguard. They can, on there, they buy 1,000 shares of Apple stock. They buy 100 shares of Meta or Facebook. All that's in their brokerage account. And in many states, that person can fill out a transfer on death and name beneficiaries who they want to receive that asset when the asset owner dies. Again, death certificates are produced. The tricky thing about that is it makes things very, very easy. But if you have one of those TOD or life insurance or IRA beneficiaries who are a minor or have maybe alcohol or chemical dependency issues where you just don't want them to get a check in a lump sum, or they just can't manage money and you want to dole out their share over time, you'll need a trust to serve as the beneficiary, so it won't be payable to that beneficiary in a lump sum. But that's another issue. All right, let me check here. Many choices, Frank says, and so many different goals and should be consulted, a life estate. Yep, so Frank Roth. I already mentioned your name earlier when I talked about the Roth IRA. Maybe it was named after you, but I doubt it. So it was named after a senator. Hey, from San Diego, sunny San Diego, fantastic. Chuck, good to see you again. And I'm going to come back to you, Chuck. So let me keep going here. So we've talked about non-probate assets, IRAs, life insurance, TOD, POD. Many banks allow their bank customers to set up a bank account and put a POD designation, payable on death. Who is the bank account payable to upon the death of the account owner? Could list the kids, whatever. Again, account owner dies, POD beneficiaries get a death certificate, bring it to the bank, and the bank releases the funds to the POD beneficiaries. Another probate avoidance mechanism is when often when married couples acquire assets, entitle them joint tenants with rights of survivorship. One of the account owners dies, ownership automatically goes to that surviving tenant, joint tenants with rights of survivorship. So, and again, states keep passing laws because probate is a burden, allowing for people to arrange certain assets, more and more assets that they own, to pass to their desired heirs or beneficiaries outside of the court and attorney involved probate. Another big probate avoidance tool is, as somebody mentioned earlier, it was Carol Chop mentioned, the setting up the living trust. So many people who own homes, who own LLCs, who own brokerage accounts, bank accounts, CDs, they'll set up as a probate avoidance tool. They'll set up their revocable living trust. They'll transfer title of their assets to their trust. Things titled in the name of your trust when you die don't have to go through probate. Your successor trustee that you designate in your trust can immediately transfer that asset to the beneficiaries that you name in your living trust without having to go through the court and lawyer involved process. So living trust is big business for probate avoidance. Also, there's some formal probate avoidance because some states allow for what's called small estate affidavits. If someone dies and their estate is less than X, and it can vary based on what the state is, it could be less than $40,000, less than $100,000. Then the heirs complete these small estate affidavits, and that allows third parties to transfer the minimal assets to the heirs without a full-blown formal probate proceeding that's going to cost thousands or tens of thousands and going to take years to complete. So the funny thing about all of this is, because we have these probate avoidance tools, there's a big dichotomy between what it takes to pass an asset outside of probate versus what it takes to pass an asset through probate. So I've always felt like I'm going to use a bad word here. I feel like it's always been stupid. That's my bad word. That, for example, an IRA owner who owns a $3 million IRA can go online and in 15 seconds change the designated beneficiaries on their $3 million IRA. But if that same person wants to leave, for example, an LLC that has a $5,000 asset in it, if they want to leave that to someone, they've got to hire lawyers and either create wills or trusts in order to leave that $5,000 LLC asset to their desired heir, where they could do the $3 million IRA beneficiary online. So I've always felt that's kind of dumb. And so we really have to look at what assets someone owns when they die to determine if a probate is necessary, and if it's necessary, what assets need to go through it. All right, now back to a couple of questions real quick. For your father, he had his house in a life estate deed, which he has TOD on bank, and we were able to transfer a car. Okay, so there you go. Small estate rules supported in Illinois. So Chuck Burkett, for his father, used several different vehicles to avoid probate. Had TOD, transfer on death, on brokerage account, probably POD on bank account. Had a life estate deed, which meant the heirs automatically became the owner when the father died. And then you had the small estate rules. I referred to it as a small estate affidavit in Illinois. It might be something like else. That something might be called something else to transfer the car in Illinois. So that's a great example of several different vehicles that were used to avoid the probate. BURPS, a non-IRA brokerage account with defined doesn't go to probate. Is that correct? So it's a non-IRA brokerage account, often does have to go through probate, unless you probably have, if your state permits it, TOD, transfer on death beneficiaries. And if that's the case, yeah, that's a probate avoidance vehicle. Good. I answered it already with so I answered it again. You got two for the price of one, Burks. Dorian Gray with Ladybird deed for house still in the mortgage. The house go to the person assigned on the deed. Yep. And can the house be sold? Yes. So an owner of a home subject to a mortgage can sell that property. Of course, the mortgage gets paid off as part of the sale because they have a lien for the amount of the mortgage. So I think the answer, there to, if I'm reading your question correctly, Dorian, is yes. Great to see you online. No minute limit for life. All right. I like your name. Keep doing what you're doing. I plan to. In fact, I plan to do it every evening in June for 6 o'clock, unless I get a better offer from my family. And I got an offer, but it came too late. We're going to go get some Mexican food. Scott, brother died about a year ago. Sorry to hear that. And he owns a third of the house and he had no beneficiaries and no will. I live in Washington. How do I proceed? Well, sounds to me like you're going to have to go through a Washington probate because your brother had a 1/3 interest in a house. So it doesn't say whether he had a will. Oh, it does say he had no will. So I don't know whether he has kids, whether he doesn't have kids. He obviously has siblings. So Washington state law will determine based on his nearest relatives and his family circumstances who his heirs are. And so you got to go through the probate, you got to hire a lawyer, prepare all the court pleadings, file all the court pleadings, get a judge to sign court orders ordering that 1/3 interest in that home be transferred to the appropriate heirs. So all those heirs participate in that probate proceeding. All right. My mother left a will, but she appointed my sister and a brother as executives, probably executors is what you meant. Also, they witnessed the will and also are benefit. Not good practice for, although, it's a, where are we here? Texas. It's a Texas state law specific issue. Normally not normally, but I've seen in many circumstances, a person who is named to receive something in the will can't be a witness to the will. Although there may be some rules out there that said if the person didn't have a will, that person could receive at least could receive what they would have received if they didn't sign a will. Complicated question, very good question, but got to take a closer state law look at that. All right, one more question, then I'm going to get back to business here. Alaska listening, very good. Elizabeth Villalobos, if I said that right, or even if I didn't say it right. All right, so I think what we've established so far, probate is the process of transferring some things that a person owns. It's a court and attorney involved process. We'll talk about the time and the money involved in it in a minute. And that there's an executor who's in charge of overseeing the process. If a person named a will and had a will and named an executor, the court appoints an administrator if the person didn't have a will to get things settled. And we clearly established that many people own assets that are non-probate assets that can pass to the beneficiaries outside of any kind of court and attorney involved process. Okay, now for the rest of this discussion, let's just go through an example where a person died. Let's say they had a will. And what's going to happen? All right, the practical answer is usually what triggers the probate is somebody died. Let's say mom died and mom had 3 kids. And one or more of the kids goes to mom's bank or mom's brokerage firm. And they're like, okay, well, we're here to get mom's money. I'm mom's daughter, or we're the 3 kids. Mom left a will. Here's the will that says I'm the executor and says everything goes to us 3 kids. We're here to just close out mom's accounts and get all of our money. And then the person at the bank or the brokerage firm typically says, not so fast. Mom's accounts are frozen. You need, and they usually say something like they go to their little folder of what they're supposed to tell the bank or brokerage firm customers. And they usually say, we need letters testamentary or letters of administration. Now, this could be called a bunch of other things, letters of independent executorship, a bunch of other things. But the kids usually hear or see on the little sticky tab note that the bank officer wrote, they see letters testamentary or letters of administration, and the bank or brokerage firm usually tells them, you've got to go to a lawyer to get these letters testamentary. Well, The kids are thinking in their mind, they need to get the attorney to write a letter and everything's going to be all good. But there's nothing that has anything to do when you hear the words letters testamentary or letters of administration. It has nothing to do with attorneys writing a letter, a dear so-and-so letter. So they shouldn't call these things letters testamentary because everybody gets it confused with writing a letter. But let's go through what does have to happen. So no, I was supposed to get a fifth of an art collection, but the family changed the will when my grandfather was suffering from dementia. Is this something I can test? How much would it cost? That is a loaded question there. Let me maybe cover that at the end because there's a lot there. Okay. What has to happen is the accounts are now frozen. And so the first thing that typically happens is a probate is the person who died had a will. In the will, they named an executor. The executor has to hire a lawyer. Lawyer has to prepare lots of court pleadings. And we have to file those court pleadings at the courthouse along with the original will. And the first step is really asking a judge to sign court orders that, number one, the will is valid, and number two, that the judge confirms, is what I call it, confirms that the daughter, if that's the case, the judge signs an order confirming that the daughter is the executor. So judges sign those court orders. Courthouse employees, after the judge signs the orders, issue these what's called letters testamentary. It could be called a number of other things, but these letters testamentary that are issued by the courthouse, and the executor gets several certified copies of them. That's the official court document that tells banks, brokerage firms, hey, this daughter here, she has the official capacity as ordered by a court to be able to handle any kind of matters related to the mother's estate. So once that first step where the executor gets confirmed, now that executor can go to all of mom's banks, any place where mom may have owned something, and they will be required to give daughter / executor all of the information on what mom owned. The daughter can get a tax ID number for the state. The daughter can open one or more estate accounts, because if there's a frozen account at the bank, then the daughter needs to open an estate account and move that money from mom's frozen account into the new estate account at the bank that the daughter, as the executor, will have signature rights over. And if maybe mom owned a brokerage account, maybe there'll be another estate account daughter / executor will open up at the brokerage firm to move those securities into the estate account that's held at the brokerage firm, because you can't hold securities in a bank account. So maybe there'll be two estate accounts. Okay, so once that's done, then there's just a process of gathering information, because it's the executor's responsibility to prepare a fairly thorough inventory of all of the assets and debts of the deceased person. So their bank accounts, their brokerage firms, their real estate, list all the values of everything, their credit card debt, their funeral expenses, attorney's fees, all of that, mortgages, all that gets listed on this detailed inventory of assets and debts that the executor is required to prepare. And so from there, usually by the time that's prepared, it's quite frankly a few months after the person died. And it seems like once a few months passes, heirs start to get antsy. They're like, man, I don't know what's going on. I don't really know how this works too much, but I haven't heard anything. I haven't seen anything. I'm supposed to be a 1/3 heir, and I think my mom probably had, a couple of $1,000,000 or so. That means I'm supposed to get $700,000 or $800,000. I haven't heard anything, but I'm starting to get nervous. Should I go hire a lawyer? What should I do? Should I go scream at the executor? Should I, what should I do? And so that's when, all this delay with not enough communication really, things start to boil over. So, but to complete the probate and get the actual assets. And sometimes I will say that the executor may have to sell the deceased person's home, so the executor can do that. And if the executor sells the deceased person's home for, let's say, $400,000, then that $400,000 goes into that estate account, which is a temporary account, ultimately, to be dispersed to the heirs. So sometimes the executor has to buy, sell, manage assets while this several month or sometimes several year process is going on. So that's typical. But then as we get to the end of it, hopefully everybody's still getting along. There's the assets, there's the debts, there's the inventory. Then typically there's some form of a proposed distribution schedule. So, and that's something that all of the heirs have to sign off on. And so all of the heirs are presented with all these court documents. Nobody understands what anything means. And they're all required to sign off on this stuff before it goes. And the one of the final, it's requested that a judge sign a final court order authorizing or ordering that proposed distribution to take place. So, for example, that final court order may say, based on the will, based on everything that's going on, based on the inventory of the assets, based on the fact that all the debts have been paid, based on the fact that the $10,000 has been already given to the grandchildren pursuant to grandma's will, a judge may hereby order that, all remaining estate assets be distributed equally to the 3 children in accordance with mom's will. And then that executor, of course, is ordered, if the executor has authorization over the estate account, signature authority, they'll disperse those funds to the 3 heirs. If mom owned 3,000 shares of Apple stock, 1,000 shares will be distributed to each of the 3 heirs. So that's all of that process, though. It takes time and it takes money, and that's where people get frustrated. I will give you a little bit of advice on things maybe you shouldn't do as part of a probate and things you should do as part of a probate. And as I go back, let's see, issues with special needs trusts. Well, I don't mean to fuss at you, but what are you talking about? No limit for life. Louisiana will asterisk, and that may refer to the previous thing. And then that's a loaded question. Hopefully I'll get to it in a little bit. Do several account numbers for different brokerage accounts complicate things versus having everything under one account? How important is it to consolidate financial accounts for will or trust? Not sure what you're talking about there. I generally say if you're going through probate and somebody died and they had, multiple accounts at multiple different financial institutions, they had an account at Schwab, they had an account at Fidelity, they had an account at Vanguard, TD Ameritrade, wherever. They had accounts all over the place. That probate is likely to last a lot longer than if everything was consolidated at maybe one of those financial institutions. Because now you've got to get the legal departments of every single one of those financial institutions to review all of the court orders, to approve things. A lot more paperwork needs to be filled out. And so, yeah, it's going to make things more complicated. It's not undoable. I mean, it's doable, but the more assets that someone has, the more work is involved with the probate, because you have to submit information and satisfy each bank, each financial institution, each heir, whatever, each insurance company, and that just takes time. All right. So Frank O is saying, Burps, in my case, that didn't work at Fidelity Investments in Florida. Something went wrong. I got burned. I'd like to know maybe a little more about how you got burned so we could all learn from it. Would you please discuss using Medicaid asset protection trust for single people in the 60s and beyond? What I'm talking about here, yesterday went through the macro estate planning. Today, and for the rest of the month, I'm going to hit individual points, and I'm going to try to answer all the questions that are somewhat related to that specific niche that I'm talking about in this particular YouTube live stream. So I'm going to hold off on the Medicaid planning for another day, which is get assets out of your name 5 years before you go into a nursing homes, so that the government or Medicaid pays for the nursing home instead of you having to use your assets. BG in Pennsylvania, another good reason to keep things out of probate is the country get a probate fee. We'll talk about, I think you probably meant to say county, but that's a key spelling there when you say country instead of county. So again, I'm going to be a little nitpicky here, and give us as much, keep it tight, but give us as much accurate information as you can in your things. All right. I have a friend, Jumba D. I want to say Jambalaya because that's so good here. Jumba D. We have a friend who is still living, and he has appointed me power of attorney and executor. Is there any value in doing a video testimonial of his authorization of me before he passes? Certain states say certain video, if you comply with rules that are almost difficult to comply with, they are permitted in court. Maybe doing a video at least lets everybody know what that person's intent is and maybe why they did it, and that might help. Might not have any legal effect, but if the purpose of the video is to communicate kind of wishes and why you're doing certain things, I generally think the more communication between the parties, the better. So if that's the extent of it, that'd be great. Will this be recorded to listen again? Yes. So Elizabeth, in a few hours, it's going to show up on my YouTube channel, and like the one I did last night, June 1st, showed up. It's there, and it's been watched, I don't know, a couple thousand times or so. So it's coming on. All right, so here we go. Don't do these things when you're going through a probate. I don't know how many times this has happened, but geez, it just kills me. Dad will die, or let's say mom dies and dad is still alive, and mom's estate, some form of the estate is supposed to go for the children, and dad gets the probate lawyer to prepare a bunch of court pleadings and documents that the children can sign. And basically what the children will be doing is signing something saying, well, I acknowledge that I have certain rights in my mom's probate, but you know what? I'm just going to let everything go to my dad. And then what happens is dad gets the whole, several $1 million estate. He goes off and gets remarried. He leaves everything to his new wife. The children are left with nothing. And then the children act like it's somebody else's fault. Well, I just signed what my dad asked me to sign after mom died. And if my dad asked me to sign it, I'm going to sign it. And so I did, but look what happened after. So you got to be careful about what you sign in a probate proceeding. If everything was supposed to go to dad when mom died, then mom's estate documents should have been structured that way to make sure she left everything to dad, but she didn't. So it's your fault for not really understanding what you're doing when you're doing something and you're doing it just because somebody asked you to do it. You can't complain about it later. Another thing that you shouldn't do in a probate is argue that you should get more because you took care of mom. So time and time again, daughter took care of mom in the last 7 years of mom's life. Two sons never so much as called mom on Mother's Day to wish her happy Mother's Day. Mom dies. Of course, the will, the trust, whatever, the will says everything goes in thirds. And daughter's like, whoa, wait a second. No, that's not fair. I took care of mom for the last 7 years. I deserve more. I should get more than my two brothers. Mom was mad because y'all didn't call her on Mother's Day. I should get more. Well, here's one, just look, you got to put your big girl panties on, and you're going to get a third. And you know what? If the only way you deserve more than third is if mom's estate documents say you get more than 1/3. So sometimes for sentimental reasons, people just, they kind of acknowledge that the legal documents say one thing, but they argue that, hey, that's just not fair. And so, look, guys, we have a set of rules, and this is the whole idea of why I'm here. Get your stuff, get it right, communicate, with your family, tell them why you're doing it. And if you want someone to get this, that, or the other, or more, structure your estate documents accordingly. But so anyway, lots of family disputes because things either weren't done right or weren't communicated properly. Another thing you shouldn't do is if a parent dies, for example, or if a spouse dies, or and you have stepchildren. Another thing you shouldn't do is just go into that person's house who died, like the day after they die, and just clean out all of their jewelry, personal effects, guns, furniture. Just clean it all out. That just sets the wrong tone for the probate. You're fixing to go through probably about a 5-year court proceeding because you did that one thing the day after somebody died. So, um, sure, let the proceeding take its course. And I realize there's all kinds of family dynamics out there, but just uh, make sure you follow the rules that you're supposed to follow. Another thing you should not do is refuse to communicate amicably. So, mom dies, 3 kids. One of the kids, who's one of the heirs, just refuses to talk, refuses to answer emails, refuses to answer phone calls. That's going to drag this thing on for years because all of the participants in a probate proceeding have to be involved, have to sign off on all the various layers of court proceedings. And if you have one participant, if there's 15 heirs and one of them is uncooperative, you're looking at use another bad word, probate from hell. So don't be that one who just refuses to communicate amicably. Now, some things that you should do are probably the most important thing to resolve a probate efficiently is communicate openly, transparently, early on. So it's just something I insist on. I handle probates in Louisiana. I'll get to how we handle, trust planning all over the country in a minute. But I've handled, I guess, thousands of probates in Louisiana, and I don't handle any of them when the heirs are fighting. But what I do is I get all the parties together. Let's say mom died. There's 4 kids. I get all the 4 kids together. Easy to do now with Zoom and technology and all that stuff. And I'm like, okay, from the get-go, we're going to be completely transparent about everything, even if only one of them is the executor. I'm like, here's the deal. Here's the will. I'll put it up on the screen. Here's the provisions of the will. Does everybody agree what the will says? Here's what we know now are the assets. Here's the debts. I'm throwing everything at you. Here's the steps that we got to take. We got to get the executor confirmed. All 4 of you will be included in every email as a group email. You'll see every pleading. And if you want to respond to an email, just hit reply all so everybody sees everything. If we need to talk about something, one of you can't call me and say, don't tell my brother I'm telling you this, but I will hang up. So if we need to talk about something, let's get all 4 of us. And that way there's that open communication. And I'm like, is that okay with everybody? And everybody's like, man, that is unbelievably fantastic. That is exactly how we want this thing to go. That way nobody's suspecting anything of doing things improperly. You see just that stress just relieved from everybody when everybody knows and is confident they're going to be included in all of the communication. So that communication early on is really, really important. And then just make sure you follow the rules. Some people think that just, if someone's an executor and the will says everything goes to the 3 children equally, some people incorrectly think an executor can just change everything and say, look, I'm getting $1 million, the other $500,000, that can be split between the others. There are grave consequences. That's an executor stealing estate assets. An executor doesn't have the authority to do that. Some people think a judge will just sign any court order because they know one of the heirs. And so the judge is going to change the intent of the person who died. Not going to happen. So just, we have a set of rules, we have a process, and it needs to be followed. And people need to realize that. All right, I'm going to get into some probate costs here next. But let's see. New York estate, 85-year-old mom, 60-year-old son, live in house. I don't even read the rest of it. House in son's name. son died and house transferred to mother with lawyer taking care of estate. Mom died 5 years ago and no other family can be located. What happens to estate? Lawyer is still keeping house in order. Good question. So I guess mom did not have a will. So every state says if somebody dies and they don't have a will, here's who it goes to. And it probably says, if they have a surviving spouse, it goes to the surviving spouse. If they don't have a surviving spouse, but they have children, it goes to the children. If they don't have a surviving spouse and they don't have children, but they had siblings, goes to the siblings. If they don't have a surviving spouse or descendants or siblings, but they have nieces and nephews, it goes to them. So each state has a who's going to inherit if somebody dies without a will. And then always at the end of that pecking order, there's like, if there's not a relative to be seen anywhere or whatever, goes to the state. I personally have never seen an estate go to the state because there's just none of those people in the pecking order exist, but it could happen. Okay, you're welcome. Advantage is the name. Advantage is the name, and thanks is the game. So that usually happens. That happened on death of a family member, wiped out the valuable things. It happens all the time. It just some people, I guess, they just feel entitled to go get everything. They're nosy. They want to be in control, so they just go wipe everything out, and then they don't get talked to for eternity. Okay, now let me go through some of the costs of probate. Really important here. There's several costs involved in probate. There are executor fees. States have different rules. Sometimes let's say it's a $2 million estate. That executor fee is typically a percentage of the assets. Sometimes it's a sliding scale. Executor gets 3% of the first $200,000, and then 2.5% of the next 200,000. I'm making this up, and then 2%, and then 1% of everything above so and so. So that executor is often entitled to a percentage of the estate. I will say the executor compensation is taxable income to the executor, whereas an inheritance generally is not taxable to the person who received the inheritance. Oftentimes, when the executor is one of the heirs, they'll waive the executor compensation, but they don't have to waive it. And then other costs, there are lawyer fees. And depending upon what state you are, you may be in a state where the lawyers are entitled to a percentage of the estate, similar sliding scale, similar percentage, whatever, 2, 3, 4%. Or you might be in what's called a reasonable fee state for probate purposes, and then lawyers must charge a reasonable fee. You can talk to 5 different people and get 5 completely different answers on what a reasonable fee is when attorneys deal with probate matters. Okay, and then there's court fees as well, because all the judges and courthouse employees have to get paid. So anytime you do anything involving a courthouse, there's court filing fees, recording fees, and all that must be incurred, often in the hundreds or thousands of dollars. All right. How long does a probate take? Good question. I would say it's always months if it doesn't roll into years. The ones that take years or multiple years to complete, it's either because the heirs don't get along well. Sometimes probates, people who are in the business of helping you avoid probate, they typically say probate is a nightmare. And people contest things in every probate. That clearly is not the case. I have been involved in probates that went smooth, I'll say. They still took some time and they took some money, but they went smooth. The ones that tend to go smooth, let's say mom died and the 3 kids, they get along. They love each other, and the kids have money of their own. So if they have to wait 6 months to inherit mom's money, no stress off the kids' back. They can wait. Oftentimes the kids get IRA money or life insurance money fairly quickly. And so if they have to wait months or years to get the brokerage account or bank account money or proceeds from the sale of a house that's in the probate, the heirs don't get stressed because of the purely because of the delay in completing the probate. So sometimes, so they don't all are they aren't all awful, but when people struggle through a probate, it's either because one of the parties is not cooperative, or the parties don't communicate, or it's difficult to get information. We talked earlier about a deceased person had accounts all over the place, maybe 10, 15, 20 different financial institutions, and it takes forever to get all the information for the inventory of assets. That can really cause things to take time. And then just what causes significant delays is just waiting on heirs to sign paperwork. I remember when my mother passed away, I was the executor and I'm one of five children. And I had to get all five children who all lived out of town to sign off on different things at different times. And it's like every time I sent something out to get the five signatures, there was always one who it would just, it'd take them an extra couple of weeks to get the signatures. And every time that happened, that delayed things by a couple of weeks. And if there's 10 different things that need to be signed by five people, and every time there's a 2-week delay, that's a 20-week delay period. So sometimes we're waiting on heirs, sometimes we're waiting on courthouse employees to process paperwork, sometimes we're waiting on judges to sign orders, sometimes heirs are waiting on lawyers to prepare the paperwork so that it can be submitted to the courthouse. And sometimes we're waiting on executors to do all the organization and paperwork and information gathering that they need to do. So any of those delays can cause these probates to last months or well into years. I have to mention a couple of other things before I get to the question. There's something called the ancillary probate. It happens often. Let's say you have someone in New York who died, but they owned a piece of property in Florida. So they were domiciled in New York, and so they had a will, and they owned assets in New York. They owned property in New York. They had a home in New York. There will be a New York probate, but the New York probate will not address or deal with any real estate owned by the deceased person in another state. So now the survivors of the person who died while domiciled in New York will have to hire a separate Florida lawyer to handle what's called the ancillary probate. The probate that's required in Florida, that is the sole purpose of that Florida ancillary probate, is to deal with that one piece of real estate that the deceased person owned in Florida, because they lived in New York, where the probate takes place. So be aware, if you own property in multiple states, it's really frustrating because survivors are having to hire multiple sets of lawyers, multiple delays. There is some probate avoidance there by either putting all of that property in one living trust, more on that other live stream, or creating an LLC to hold that Florida property. Now that LLC that New York domiciliary owned can pass through the New York probate, but the real estate owned individually by the New York domiciliary, if it's in Florida, you have to do the ancillary probate. So and having that property owned by an LLC can avoid that ancillary probate. Okay, so probably not worth completing a discussion about probate than by talking about some of the ways that probate can be avoided. So you really have to look at everything you own, and you have to see, okay, what do I have that's a non-probate asset? IRA, check. I've got my beneficiaries designated. Life insurance, check. Got my beneficiaries designation. Oh, but I own the home and these rental properties and my LLCs, and those are probate assets. So the most talked about and most utilized probate avoidance tool is that revocable living trust. I've made a number of videos on that. The idea is you create your living trust, you transfer those probate assets to your trust. things that are in your trust when you die. They don't have to go through the court and attorney involved probate proceeding. You designate a successor trustee who can transfer those assets immediately when you die or sell your home the day after you die without having to go through that court and attorney involved process. They can transfer the assets to the trust beneficiaries. The trust really replaces the will. So that one's really popular. As I mentioned on yesterday's live stream, there's a couple of ways to do it. You can go to your local lawyer. My role here is just to get you to take some action, get you to where you have enough information. So you're like, I can get this thing started and I can get this thing done. So there are thousands of lawyers all across America ready and willing to help you. I'm on a listserv with thousands of them, and everybody's seems to be kind of hoping they can get more clients. So so you should probably maybe talk to 2 or 3 before you make a decision. So there's lots of lawyers out there likely in your town and your city who can help you. You want to look for the estate planning lawyer, the lawyers that do estate planning. It's its own little niche. It's not personal injury law. It's not car wreck law. It's not bankruptcy. It's not real estate. It's estate planning. You'll look for that. There's some online ways you can, mechanisms available to do some estate planning. I have a law firm. My YouTube channel got so darn kind of, I guess, popular 6 or 7, about 4 years ago. So many people from all over the country asked me if I could help them. I formed a national law firm, America's Estate Planning Lawyers. And so between the staff that we have in our office in Louisiana and all of the co-counsel relationships that we have in all of the other states, and, states like California, New York, Illinois, Nevada, Oregon, Washington, all the big ones. You can contact our office or in the description of this video, you'll see our website, aeplawyers.com. Or if you just want to request a Zoom meeting with me, there is a link where you can fill out a questionnaire and request that Zoom meeting with me just to have an initial conversation to see if this is if it's appropriate for us to help you with that. So anyway, I don't want to talk too much about my stuff. Let me go back to the questions. All right. Let's see here if I missed some here. As we go back, I'm getting older, Elizabeth says, have wonderful daughter with special needs. Okay, it's difficult to find people who will be just BD protective. I'm not sure what BD be protected with her. Okay, so yeah, I'll have to do that as a special live stream. Special needs trust. Often people with disabilities, children of yours, they are getting certain benefits from the government because they're disabled. If you leave them an inheritance, they lose their benefits. You can leave it to a special needs trust that's used for certain purposes for them, and it protects their government benefits. And it looks like you're looking for somebody to help with that. No heir to mom. Thank you so much. Great. I'm on 2-year waiting due to mishandling of my father's. Hey, Paul, if you have a piece of land that is does it go into survivorship? Okay, I think we've talked about that before or yesterday. Just trying to go fast here. Upon death of a holder of a living trust, can the successor trustee give the assets to the beneficiaries of that? So upon the death of, you say the holder, that's, I would say maybe the settlor or the trustor or the person who set up a living trust. Can the successor trustee give the assets to the beneficiaries without any lawyer involvement? Before I gave a blanket yes answer to that question, I think I need to know more circumstances. I need to review the trust instrument. I need to know what kind of assets exist. I need to know whether there's any debts that the successor trustee of the trust is responsible for paying. But generally speaking, the way it usually works, yes, if there's a trust bank account or if there's a trust brokerage account, that successor trustee goes to that financial institution with a copy of the trust showing that they are the successor trustee with the death certificate of the person who set up the trust. The financial institution's legal department will likely review those documents and then approve that the successor trustee gain access to the account and allow for that division of assets. So hope that helps. Do you have relationships in Colorado? Of course we do. Be happy to help. See the link in the description below. Been listening to your channel, went in for my estate planning. I feel secure. Good. That's the idea of this of my YouTube channel, just trying to get more people to get this stuff taken care of. There's all kinds of statistics. X percentage of people did not die without a will. X percent don't update their stuff when there's a major change in family circumstances. just trying to draw attention to the subject matter so we can avoid a lot of these problems in estate settlements. Okay, I'm going to go eat some Mexican food with my family, my wife, 2 of my kids, my daughter-in-law. I've got 5 kids. 3 of them are already lawyers. The other 2 are in law school. So we got a family of lawyers here, and my son's married to somebody who's in medical school, and another son of mine is married to a lawyer. So like at the rehearsal dinner, I said, I'm going to start a law firm, Rabalais, 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 and Rabalais. So there was 8 of us, me, my 5 kids, a daughter-in-law. I don't know, so many lawyers. So anyway, it was a kick. Y'all take care. We'll see you tomorrow. We'll have another live stream, 6 p.m. Central Time tomorrow. Y'all have a great night. See ya.